Welcome back to the Legal Brief, the show where we crush the various legal myths and misinformation surrounding various areas of the gun world. I'm your host, Adam Kraut, and today we are answering some of your most asked questions and correcting a few things that I got wrong.
TacPack offers some of the highest quality tactical and EDC gear in a monthly package shipped right to your door. They aren't focused on sending you a bunch of crap. They want to make sure that you get gear you will actually use, featuring things like knives, tourniquets, multi-tools, AR-15 parts, and survival gear. TacPack is bound to have gear that you're going to love. If you order right now, you can get either a free hat or a free multi-tool by using the code TGCHAT or TGCTool at TacPack.com.
As you guys know, the point of this show is to spread correct information in the hopes that we can get rid of a lot of the myths and misinformation out there. In the comments, a few of you have pointed out things you didn't think were quite correct, or I managed to catch something I said later on that wasn't phrased correctly. In the spirit of being right and not being afraid to admit when I make a mistake, I want to point out a few things that need clarification. Some of you may remember episode 23, the one where we covered any other weapons or AOWs, and guys, there's a ton of information we've already covered, so be sure to check out the playlist on YouTube. On the screen, we flashed a few images when we were discussing some examples, such as this pen gun and this belt buckle gun. When I was reviewing the final cut of this episode without having finished my coffee, I failed to catch that neither example is an AOW. You may be asking yourself, why is that? Well, in relation to the pen gun, because it folds down and looks like a handgun, it is taken outside the purview of an AOW since it's no longer disguised. However, a true pen gun would be an AOW because while it looks like a pen, it is capable of being concealed and can discharge a shot. The belt buckle gun is not an AOW because you actually have to remove it from the buckle to fire it. However, a belt buckle gun like this old Nazi buckle would have been an AOW because it is capable of being concealed and can discharge a shot. However, it is now considered a curio and relic and was removed from the purview of the NFA by ATF. The reason for that? The Bureau has determined that certain firearms on the list are primarily collector's items and are not likely to be used as weapons by the reason of the date of their manufacture, value, design, and other characteristics. Thus, they are excluded from the provisions of the NFA. The other thing I wanted to correct came from episode 27, where we covered when you lose your firearms rights. In that video, we discussed the definition of a crime punishable by more than 1 year imprisonment to not include a state law misdemeanor crime punishable by a term of imprisonment of 2 years or less. When translating it into something a little less legalese, I stated that a person who was convicted or pled guilty to a state law misdemeanor crime punishable by 2 years or more, they would be a prohibited person. Here's the clarification to that. If the state law misdemeanor is punishable by more than 2 years imprisonment, that person is prohibited under federal law. If the state law misdemeanor can be punished by imprisonment of up to and including 2 years, they are not prohibited under federal law. So there's a little clarification for you guys. Now, before we move on, I just want to clarify one other point. With a number of new viewers joining the ranks, and thank you guys for watching, I continue to receive questions from viewers about their particular circumstances or other states' laws. If you ask me a question pertaining to your specific situation, odds are you're not going to receive a response. The purpose of this show is to explain the law, not give you advice as to the legality of what you are doing. Furthermore, I'm only licensed to practice law in Pennsylvania and at the federal level. As such, my commentary on other states' laws and proposed laws will be limited in nature. It's not that I don't want to help you, but in cases like that, I can't. Now, I think you guys notice I do respond to questions in the comments frequently, but the email ones are a little bit harder for me to keep up with. Here's a few topics that I've gotten a number of emails about. A lot of you want to know about medical marijuana and firearms ownership. While a number of states have been legalizing marijuana in some fashion, mainly for medicinal purposes, it is still illegal at the federal level. As such, if you're a user of medical marijuana, according to federal law, you are an unlawful user of a controlled substance and would be prohibited from purchasing or possessing firearms and ammunition. ATF had even released guidance to FFLs that if you use your medical marijuana card as photo ID, the licensee was to terminate the sale because you're an unlawful user for the purposes of federal law. Long story short, if you use marijuana for any purpose, you are a prohibited person. And another thing from the AOW episode a number of people inquired about was how the Black Ace's tactical firearm was not a short barrel shotgun or an AOW. In order for a gun to be classified as a short barrel shotgun, it must be a shotgun with a barrel length of less than 18 inches or any weapon made from a shotgun with an overall length of less than 26 inches. As we discussed previously, in order to be a shotgun, the firearm has to, among other things, be designed to be fired from the shoulder. Since the receiver Black Aces uses was never a shotgun, it cannot be a short barrel shotgun. The reason it's not an AOW is a little more complicated, so bear with me. Remember, we're not dealing with a shotgun. When we look at the definition of an AOW, we see that the term includes a pistol or a revolver having a barrel with a smooth bore designed or redesigned to fire a fixed shotgun shell. While this would seemingly include the Black Ace's tactical firearm at first blush, it does not, due to its vertical foregrip and the gun's overall length. The firearm cannot be a pistol because of its vertical foregrip, since it's no longer designed to be held and fired with one hand. However, it could be an AOW. With an overall length of more than 26 inches, it places it outside of what ATF considers to be concealable, thus removing it from the purview of being an AOW. However, ATF has previously stated that that 26-inch figure is only a presumptive standard and is not set in stone. If that firearm were to meet the other criteria of an AOW, and it does, and there was evidence the firearm in question was concealed on a person, it could potentially place that firearm back into the category of an AOW. I've included that determination letter in the description. I continue to receive questions relating to the Hearing Protection Act, or HPA, and it's not really surprising given that topic's been one of the most popular ones we've covered. 2 times. The questions you guys are asking include things like, when will it pass, will it include the refund, and how will it affect me using my trust? Earlier in March, I spoke with one of the executives of a well-known silencer manufacturer. They had relayed information to me from a meeting with congressional leaders that indicated that the HPA was not going to be up for a vote this year, and there were serious concerns about eliminating the tax revenue generated by transfers and manufacture of silencers, let alone a retroactive credit of taxes already paid. In short, it doesn't seem like the HPA will be heading to the floor this year, at least not without some major reconciliation and changes. However, that does not mean you shouldn't be picking up the phone and calling your congressional representatives to act on this bill. If the HPA were to pass how it's currently written, there's nothing that would prevent you from adding silencers to your trust. However, they would be treated like any Title I firearm, and the whole use and possession aspect would no longer be a concern, unlike with a Title II or NFA firearm. Remember, if you think you catch a mistake, don't be afraid to let me know either in the comments or by dropping me a line. I'll be the first person to admit when I make a mistake, and since the purpose of the show is to disseminate correct information, I have no problem making any corrections, as you probably noticed. I do my best to get this information correct, but I'm not perfect. Occasionally, mistakes happen. If you guys like this episode, you know what to do. Hit that like button and share it around with your friends. Have a question you want answered on the show? Let me know down in the comments below, or on the legal brief section of theguncollective.com. Be sure to check out my website, adamkraut.com, for more information on my quest to serve you on the NRA Board of Directors. And don't forget to like The Gun Collective on Facebook, Instagram, YouTube, Full30, Snapchat, and wherever else you can catch us on social media. And as always, thanks for watching.
We do our best, or I do my best, if you want to say that. I do my best to get this information correct, but I am not perfect.
Yes, I am.
Shut
up. Put that in there.
The shirts worn in today's episode of The Legal Brief have been provided by Patriot Patch. Click the link in the description to learn more.